Bismillahirrahmanirrahim. Myself Zainab Islam. Today I am here to present a topic of arbitration in ADR. Firstly, we will discuss about arbitration. Arbitration is a method of ADR, alternative dispute resolution, in which two contending parties decide to submit their dispute to a neutral third party, which is called as arbitrator. He can be a one or more than one person, and his decision is binding on the parties. It is alternative to traditional legal system, and it is out of court settlement. It offers flexibility and confidentiality, and it is commonly used in commercial, labor, and international dispute. Like the flowchart displays the process of arbitration, where two parties in dispute appoint third person and they all together solve their dispute. Here are some fundamental features of arbitration. Firstly, it is an alternative to traditional court system. It is a private method for dispute resolution. Arbitration proceeding and rules like UNISTRO rule or New York Convention rule, what the parties want to follow, can be chosen by the parties, and the neutral arbitrators also can be chosen by the parties. It is finding and binding decision on the parties. The merits of the decision cannot be challengeable in the appellate courts, as courts can't review or change the decision of arbitrators. Neutrality is one of the major elements or backbone of arbitration, as business causes arbitration null or void. Confidentiality should be maintained, as it is one of the major elements in each method of ADR. If the arbitration award is given, its enforceability becomes easy. Here is the procedure of arbitration. Firstly, there is an arbitration agreement. It is the foundation of any arbitration. It is a legal contract where parties agree to submit their dispute to arbitration instead of going to court. Commonly, it is a small clause within a large business contract, which is called as arbitration clause. If no clause exists, parties can sign this agreement after a dispute has already arisen, or the court can also refer a case to arbitration. Once signed, it generally strips the national courts of jurisdiction over the matter. Secondly, there is a notice of arbitration. The process officially starts when the aggrieved party, which is called as claimant, sends a formal notice of arbitration to the other party, the respondent. It alters the respondent that legal proceedings have begun and stop the clock on any statute of limitation. Then there is an appointment of arbitrators. Like judges who are appointed by the states, arbitrators are appointed by the parties. They can be one or three or in any odd numbers to keep neutrality. In case of three, one arbitrator is from the one party and the second arbitrator is from the second party. And the third arbitrator is generally chosen or appointed by the ADR center, or it can also be chosen by the selected arbitrators. Then there is a preliminary hearing. Shortly after the tribunal is formed, a preliminary hearing is held in order to establish the procedural timetable. The arbitrators and parties discuss deadlines for pleading, the scope of discovery, and the date for the final evidentiary hearing. Then there is a submission of pleading. Pleading are actually the formal written documents where each side lays out their full legal case. Then there is two statements, statement of claim and statement of defense. In statement of claim, there is a claimant's detailed variant of the facts and legal arguments. In the statement of defense, there is a respondent reply, which may also include a counterclaim. Then there is a discovery and hearing. In discovery, parties exchange relevant documents. In arbitration, this is usually much more limited and faster than in a court of law to keep costs down. Then there is a hearing. The hearing of arbitration is in a private conference room to keep confidentiality. Unlike in courtroom in a formal meeting where lawyers make arguments and witnesses are questioned or cross-examined, where the confidentiality can't be maintained. Award. Once the hearing concludes, the arbitrator deliberates and issues a written decision called as award. The award is final and binding. This is generally no right to appeal the merits of the decision, as the court co- or judge can't review or change the decision of the arbitrator. Then there is enforcement. If the losing party refuses to pay or comply with the award, the winning party must seek enforcement. The award can be converted into a court judgment and enforced by local bailiffs or sheriffs. Now we will discuss the types of arbitration. Firstly, ad hoc arbitration. It is a type of arbitration in which the parties and the arbitrator manage the process themselves without a middleman institution. They may create their own rule or use existing ones like the UNISTRO rules. It is often more flexible and cheaper but requires high cooperation between the parties. For example, the two traders in Lahore have a dispute over the quality of grain shipment. Instead of going to a formal body, they agree to hire a respected senior trader or a retired local judge to decide the case. They don't use a specific organizational rule, they simply follow the Arbitration Act 1940 and manage the dates and venue themselves. Then there is an institutional arbitration. It is a type of arbitration in which the parties agree to use a professional organization like the ICC, International Chamber of Commerce, LCIA, London Court of International Arbitration, or AAA, American Arbitration Association, to administer the case. The institution provides the rules, selects or confirms the arbitrators, and manages the timelines. For example, a large construction firm in Lahore enters a contract with a Pakistan Engineering Council PEC for a government infrastructure project. If a payment dispute arises, they use the PEC rules of conciliation and arbitration. The PEC act as the institution, providing a list of approved engineers or lawyers to act as an arbitrator and ensuring the process follow their specific updated guidelines. Then there is a domestic arbitration. It is a type of arbitration which occurs when both contending parties are from the same country and the dispute is governed by that country's national laws. For example, a dispute between Sui Northern Gas Pipeline Limited (SNGPL) and local industrial factory in Faisalabad regarding gas billing. Since both parties are Pakistani entities and the contract was signed and performed in Pakistan, this is a domestic arbitration governed by Arbitration Act 1940. Then there is an international arbitration. It is a type of arbitration that involves parties from different countries. It is a preferred method for cross border businesses because it avoids home court advantage one party might have in their own national court. For example, a French luxury brand sues a Dubai distributor to supply counterfeit goods. In case of any dispute, they can go for international arbitration because they are from different legal system. For example, ICC, ICSID, or AAA. Then there is an investment arbitration. It is a type of arbitration that arises when there is a dispute between a foreign investor and a sovereign state. For example, Rico case is one of the most famous legal battle between Pakistan and Tatian Copper Company (TCC), a joint venture of Barrick Gold and Antofagasta. The dispute actually arose by the cancellation of mining lease by the government of Pakistan. After spending $200 million for 10 years on exploration and feasibility, TCC applied for formal mining leasing, which get rejected by the government of Balochistan by saying that it is not good for the people of Pakistan. A petition was filed in Supreme Court of Pakistan, and Chief Justice Iftikhar Chaudhary declared that the entire 1993 contract void ab initio, legally invalid from the start. This triggered the TCC, and they went to international arbitration and took Pakistan to ICSID, International Center for Settlement of Investment Dispute, in Washington. In 2019, the tribunal award charged Pakistan with damages of $6 billion. This led to years of negotiation, eventually resulting in a new out of court settlement in 2022, where the project was reviewed with new terms. Then there is a statutory arbitration. It is a type of arbitration mandated by a specific law rather than a contract. In this, the arbitration is conducted by certain special laws which specifically provide for arbitration in the respect of dispute arising from matter covered by those acts. For example, the Electricity Act 1910 or Cooperative Societies Act 1925. In Pakistan, certain disputes are legally required to be settled by an arbitrator appointed by the government. For instance, if there is a dispute over the value of land being acquired for a new railway track under the Land Acquisition Act, the law may mandate an arbitrator to decide the compensation regardless of whether the owner wants to go to court or not. Here are some advantages of arbitration. It is flexible. It means that if the parties are not agree with the decision of arbitrator, they can go to court. It keeps confidentiality, which is the major element of each method of ADR, as the litigation is public. It is speedy and cost effective. However, on the other hand, a civil suit in Pakistani courts can take 5 to 10 years to reach a final judgment due to repeated adjournments. Arbitration can often be completed in 6 to 12 months. The language used in arbitration is very common and traditional language, which can be understandable by the parties. However, in the litigation, the language is too much formal. The parties can't understand it. The decision of the arbitrator is final and binding on the parties. Here are some disadvantages of arbitration. It has less expertise. It means the practitioners or the lawyers are not interested towards arbitration. In arbitration, there is a limited or no right to appeal, which is the biggest disadvantage of arbitration. Once an arbitrator makes a decision, it is final. You cannot appeal it just because you think the arbitrator got the facts wrong. It means that there is no appeal against the merit of the decision. It has limited discovery. It means the arbitrator do not have the same power as the judge to force a party to hand over hidden documents. They rely largely on the good faith of the parties. However, the arbitration saves time. It is not always cheaper. In a court, the government pays the judge salary. In arbitration, you pay the arbitrator's hourly fees plus the venue and administrative costs. Arbitration on international level is generally regulated by the New York Convention 1958. It is the most important treaty. It requires 170 plus countries, including Pakistan, to recognize and enforce arbitration awards made in other countries. This is why a win in London can be used to seize assets in Karachi. Universal Model Law. A template law provided by the UN. Many countries like Singapore and Australia have copied this template into their own national laws to ensure their legal systems are arbitration friendly. ICSID Convention, International Center for Settlement of Investment Dispute, 1965, specifically for investment arbitration. It provides the rule for when a private company sues a country. The other international laws like International Chamber of Commerce, Singapore International Arbitration Center 1991, and Hong Kong International Arbitration Center 1985, and other are AAA, American Arbitration Association, are you also regulate international level arbitration. Arbitration in Pakistan is generally regulated by the Arbitration Act 1940, which is called as domestic arbitration, as it governs dispute where both parties are Pakistani. It is often criticized for being outdated because it allows local civil courts to interfere too much in the process, which can cause delays. Recognition and Enforcement Arbitration Agreement and Foreign Arbitral Awards Act 2011, which is also called as International Arbitration. It is much modern as it implements the New York Convention, meaning if you win an arbitration in London or Singapore, Pakistan high courts are legally bound to enforce their decision here in Pakistan, with very few exceptions. The Draft Arbitration Bill 2024 or 2025. It aims to replace the 1940 Act with a law based on Unistrol model law. It aims to limit the power of civil courts to stay or interrupt arbitration proceeding, making the process much faster and more reliable for businesses. To conclude, I must say that arbitration is one of the most widely used and accepted method of alternative dispute resolution, offering numerous advantages our traditional legal system. Understanding its procedure, types, advantages, disadvantages, and legal framework governing it is essential for businesses and individuals seeking efficient and effective ways to resolve their disputes. In the end, I must say thank you for watching the video.